Good evening, everyone, and very happy evening to everyone. I welcome our today's guest speaker, Dr. Santosh sir. He has been very nice to give time from his so busy schedule, and this is his second lecture on this topic. So he's a very well-known personality. He has got a lot of achievements and qualifications. He did his post-graduation in surgery as well as orthopedics, and then he did his law degrees up to the highest level achievable in the law. At present, he is a faculty at Symbiosis University, Pune, and is looking after the whole channel. Sir, please say something about you, and then you can continue with the talk. You are
So,
muted, sir.
yeah. Good evening to all. I hope I am audible.
Yes, sir. Nice.
Ah, So, uh, at the outset, let me thank Dr. Mahesh Sinha sir, who is a senior anesthesiologist and a critical care specialist from Raipur. I am thankful to you, sir, for inviting me for having an interactive session with uh, uh, quite a number of, I hope all are the anesthesiologists who have joined.
Sir.
So I also welcome Dr. Shivkumar Kumar. He is from Karnataka, and he is also a well-known faculty. He himself is an anesthesiologist. So I'm sure he will help me wherever I will need during this presentation. So thank you very much. Uh, Friends, because of the invitation by Dr. Mahesh Kumar Sinha sir, I'm again here to have an interactive session with all of you. So, we have last time briefly seen some of the provisions of the Consumer Protection Act 2019, how this Consumer Protection Act is applicable to the medical profession, and uh, the this particular field, medical legal field, how it is evolving. So, being an anesthesiologist, you are always involved in the emergency situation. May it be in the operation theater, or may it be anywhere in the wards or in the hospital, wherever you are called for. Now, we have been listening to this, that nowadays there has been a change in the overall attitude of various sections of the society, and the doctors, the medical professionals, they have been facing a lot many legal problems while practicing their own specialty. After the application of the Consumer Protection Act 1986, when this act was applied itself to the medical profession by Honorable Supreme Court's judgment, Indian Medical Association versus VP Shanta, number of cases were filed against medical professionals. And that was a time when the medical professionals gradually started knowing about how the law takes care of the patient's rights, and the patients have rights, and the patients are equated to the consumers. A number of cases were filed against medical professionals, number of judgments came, and then uh, with due course of time, because of number of judgments which were delivered by Honorable Supreme Court of India, various principles got evolved, and gradually the medical professionals across India, they came to know that there has been a boundary, it's a legal boundary to their medical practice, and beyond which, definitely, if something happens, the doctors are liable for their uh, actions. So may that action be act of omission or act of commission. So due course of time, a number of experts, they started studying this particular aspect, and the medical professionals who got qualified in the law, in the field of law, the in short, the legally qualified medical professionals or the doctors, their number is gradually increasing. Now, being a doctor, we are now aware that the Consumer Protection Act is an act which takes care of the patient's rights as consumers. We were already knowing that the Medical Council of India has the responsibility to not only monitor the medical education, but also the medical profession as such. Now, uh, I always say that being a medical professional, when I practiced as a general and orthopedic surgeon for 20 years, I was always interested in knowing that when the in the court of law, when except doctors, no other person, that is advocates, judges, patients, they don't have medical knowledge, then how they decide, how the court decides that a certain doctor is liable for his action or her action. Due course of time, when I got the opportunity to be on this side as a member of the State Consumer Commission, judicial work was assigned to me. During that time, I could actually understand that there are certain principles based on which, or the acts and laws which were actually enacted by the Parliament of India, and then later on uh, uh, interpreted by various courts, mainly the Supreme Court of India. So, what are the acts or laws that are actually applicable to the medical profession? We are aware that we know actually, apart from the Consumer Protection Act, a doctor can be liable in criminal courts, specifically when death takes place, mainly the death in the operation theater or death of a patient during surgery. So, criminal liability and civil liability, these are the two important words, two important terminologies which came into existence. And then gradually we started knowing that such a thing exists. Now, apart from the ethical regulation by Medical Council of India, then the civil liability, mainly in terms of consumer protection, and the uh, ethical regulation by Medical Council of India. So these are the two aspects. Criminal liability, as discussed under the Criminal Procedure uh, Code, and the uh, IPC, that is uh, and the IPC. So the criminal laws, apart from those criminal laws, there are special laws which are applicable to a profession. So now I'm going to share with you the presentation, and I have tried to uh, briefly sum up certain aspects of the various laws to applicable to the anesthesia logy as such. Yes. So I hope now this presentation is seen by all of us, and it is full screen.
Yes, sir.
Thank you. Thank you very much. So the anesthesiology in India, navigating laws and ethics. So this is a general theme. And apart from that, I'm going to uh, discuss or speak about some of the important judgments. Of course, it's not possible to discuss all aspects of the various landmark judgments, but a few of the judgments I'm going to discuss with all of you. Yes. So key laws that govern anesthesiologists can be broadly discussed under two headings. So laws that take care of the professional practice and the laws which take care of the patient safety. These are the two important broad headings under which the laws can be discussed. Under the professional practice as such, the basic education requirements for licensing and registration, that means the registration with the Medical Council of India, then the scope of the practice and the limitations of the practice, they have been discussed and defined under the Code of Medical Ethics. Code of Medical Ethics 2002 also discusses the professional misconduct and disciplinary actions that can be taken by the Medical Council of India. We all are aware that now the National Medical Commission has already taken over, and almost all those provisions which were previously existing, they are existent in the National Medical Commission Act. So this is about the laws which take care of the professional practice. The laws which take care of the or monitoring of the patient safety are informed consent and the patient rights. So the though there is a no separate law as such for informed consent, it is the Honorable Supreme Court's judgment, Sabira Kohli's judgment. I'm going to discuss shortly afterwards. So this informed consent and the patient's rights. So patient's rights as consumer. Then laws that take care of the drug administration and monitoring of the uh, drug administration and reporting of adverse events and incidences. So the law specifically uh, casts responsibility of treating the serious patients or while giving anesthesia. The laws take care of the patient safety. Now, Indian Medical Council Act 1956, as we discussed, takes care of professional conduct and the medical education. The professional conduct means it defines what is the professional conduct. So, how or what can be the relationships between the patient and a doctor? Relationship between a doctor and a doctor, that is a professional and a professional. Then a professional and the other employees in the hospital, like the nursing staff, the other staff as such. Now, it also provides the framework for maintaining ethical standards. So this is one. Then the other aspect is the medical education. The Indian Medical Council Act 1956 used to regulate the medical education, medical education and institutions, and the standards were to be maintained as per the provisions given in the Indian Medical Council Act. The Code of Medical Ethics 2002, it has under seven, we can say, chapters. It discusses about the ethical aspects of a medical professional's practice, that is a profession. The two important acts with the perspective of an anesthesiologist are the Drugs and Cosmetics Act 1940, which defines the drug control and the safety. It regulates the manufacturing and the distribution, sale and distribution of drugs and cosmetics in India. The reason why this act was enacted and why this is existent is that the quality of the drugs, the manufacturing of the drugs, and even the cosmetics with the purpose of medicinal use. This was the main important aspect, and the safety aspect has been considered and taken care of in this act. Licensing and standards have been discussed. I'm not going to go into the much details and the depth because the act is also available on the net, which we can go through. The licensing requirements and the standards for quality, labeling and packaging drugs and cosmetics. So these aspects have been spelled and have been taken care under the Drugs and Cosmetics Act 1940. So the another act is the uh, Narcotic Drugs and Psychotropic Substances Act. Now, why this is important? Because anesthesiologists every now and then uses certain drugs which are very much important in the safety of a patient. So the control and regulation of the narcotic drugs and the use of psychotropic substances have been controlled by this particular act. So it has spelled the licensing and permits, who is authorized, who is qualified, and what safety should be there, which must be monitored while using these drugs. So that this has been in various provisions have been mentioned in this act. Of course, every act has the enforcement and penalties. So this act also has strict measures while enforcing this particular act. Next act is the Radiation Protection Rules, 1971. Now, while in the operation theater, the surgeon as well as anesthesiologist, they are busy with the operation or a surgical procedure of a patient, during which the various types of machines which are used, which are emitting radiation, like in orthopedic procedures, we know that the C-arm is used or continuous monitoring of a patient is being used. And so the protection of X-ray machines are also used in the operation theater. Now, uh, as per these rules, the protection is of an individual, that is, those who are involved in the treatment. So their protection is taken care of. So this promotes the responsible radiation practices. Now, what is the regulation? Regulation is that the licensing requirements are there. The radiation dose limit has been set. Now, monitoring of radiation doses and safety protocols for handling radioactive materials. So while giving treatment to cancer patients for specifically these radioactive materials, they are being used. And anesthesiologist is every now and then he's available. So he should know, rather he must know, if whenever he is involved in such kind of a treatment, he must know what are the protection rules as such. Now, uh, briefly, I'm going to consider these two judgments, which are important while uh, considering the patient safety as such. Samira Kohli versus Dr. Prabha Manchanda. So this case, this Honorable Supreme Court, by this case has uh, given the important aspects of the informed consent. Now, while uh, treating any patient, we all now aware that the consent of a patient is important. Now, even while operating upon a patient during a surgical procedure, the surgical consent is different from the anesthesia consent. So we all are aware about it, and I hope and I'm sure the hospitals as well as the qualified anesthesiologists, they have developed their own skills and techniques and the documentation as such. So it forms a very important aspect that you must take the informed consent of the patient. Now, in this case, what happened? I'm sure you must have gone through this case as well, or the details you must be knowing. Now, Samira Kohli was a patient. She was a 49 years old patient, 49, cross 45 years. So for abdominal pain, she consulted Dr. Prabha Manshinda, and for which she underwent diagnostic laparoscopy. In short, what happened? So this is a case from Delhi. In short, what happened was, while going ahead with the laparoscopy, the treating doctor found endometriosis as the cause for the abdominal pain which the patient was suffering. Now, thinking that under only one anesthesia, now the treatment can be given to the patient. The final treatment can be given to the patient, and so her mother was consulted, and she was informed that, see, now for this the pan hysterectomy is the answer, and if you permit, we will proceed ahead. Accordingly, mother said, okay, you go ahead and do it. So when the patient was awake after the surgery was over, she came to know that for her pan hysterectomy was done, means removal of uterus as well as the both ovaries were removed. Now she was an unmarried lady and she had a boyfriend, and she had intention to get married, etc. etc. So the litigation that proceeded and that followed afterwards, finally the Supreme Court uh, heard this particular case and came out with certain principles that the informed consent is a must and the patient's consent is the most important. So who should give consent is the patient who should give consent. So the principles which were laid down, I'm not going into the much details and legal terminology as such, but the principles which were laid down by Honorable Supreme Court, that the uh, patient has full authority to decide what should be done with his or her body, and hence every aspect of a treatment must be informed, and this is how the informed consent has become very important, and for anesthesiologists it is far more important. Now, certain other parameters which were discussed by this particular judgment, that the treating doctor must take the consent. Who should give the consent is the patient who should sign, and the patient must understand and then sign. If the patient is not able to understand, then the legal guardian must sign the consent. And the details of the disease and the treatment must be discussed. What are possible complications in this particular surgery, that also must be discussed. So is true for the complications of anesthesia. So that also must be discussed, and thus the informed consent must be uh, obtained from the patient. Now here it was largely discussed among various groups of and various associations, and uh, the final conclusion was that even if the patient is under anesthesia and when the uh, surgeon thinks that this is the right treatment, without the consent of the patient, no second surgery should be obtained, and the no second surgery should be performed. And then uh, this uh, uh, rather, it should be done at a second instance. So that was also discussed after this judgment came out. Now, one more. I think I will answer the questions at the end. So we discuss initially with all aspects, and then we will again start discussing the questions and answers. Right. So Bolam versus Tryon Hospital Management Committee, 1957. This is a case of a UK. Now this case actually formed a mainstay of the medical negligence or medical malpractice cases throughout the world. So, in short, what happened was, Bolam was the name of patient. He was a 65 years old male patient, a psychiatric patient, while undergoing the electroconvulsive therapy. Suddenly, without anesthesia or without relaxant drug, the electroconvulsive therapy was given to the patient, and patient suffered from a hip fracture. Now, of course, litigation followed after this outcome, and uh, the Justice McNair was the judge who heard both the sides. Both the sides, they laid down the expert opinions, and the Justice McNair said that whenever the treating doctors follows the accepted principles of the treatment, which are being followed by similar medical professionals or similar, we can say, uh, the doctors who are medical professionals who are practicing the similar specialty, they follow, there is no negligence of negligence in treating the patient. So this was a boon, rather is a boon to the uh, medical profession as such. Later on, of course, the another 1997, there was a Bolitho case. Of course, I'm not going to right now discuss that Bolitho case, but in short, the uh, it added that the expert opinion, whenever it has been placed before the judge, must be rather uh, examined on the basis of logical analysis principle. Now, this was, of course, not much of this thing. Aruna Shanbag's case, we know this case discussed the passive euthanasia. So, in this case, we all know that the she was a nurse in a large hospital in Mumbai, and in an attempt to rape, she was actually strangled, and she went into coma. She was in a vegetative state for a long time. Obviously, she was taken care of by the staff, and uh, the court did not permit the uh, passive, rather euthanasia, that means mercy killing, was not permitted in this case. So this was, it's a just not much related with anesthesiology, but a patient uh, who can be in a vegetative state, the outcome of a treatment, if suppose in a vegetative state, the such a patient cannot be offered, even if they sign, the relative sign, you cannot offer euthanasia. So this was just an outcome. Now, coming back to the ethical consideration for the anesthesiologists. Now, as per the Code of Medical Ethics or the Medical Council of India Act, these are the four important principles which one should know, one should understand. So patient has an autonomy, means patient has all authority to decide what should be, whether patient should receive a treatment and what kind of a treatment patient should receive. So even after informing the details of the treatment, patient has the autonomy. So this is the first principle, which is quite important. Second principle is the beneficence. That means the doctor must act only in the benefit of the patient. So the well-being and the safety of the patient must be considered while treating the patient. Third principle is a non-malfeasance. Meaning is that malfeasance means wrong treatment. So a principle in which the wrong treatment should not be administered or given to the patient. So this is the third principle. Fourth principle is the confidentiality. This is again far more important. The confidentiality must be maintained by the medical professionals while treating such a patient. So whatever may be the information which comes out, or it must remain confidential. So this is what is the it's a meaning. Now, coming to the best practices and compliance measures for anesthesiologists. This is, of course, my first presentation. In the second presentation, I'm going to discuss about certain case laws, and then we will be discussing or in an interactive fashion the other aspects of the legal compliance in anesthesia practice. So the first one is the continuing education. So The as others doctors, the anesthesiologists also should rather must remain updated in the latest advancements, guidelines, and best practices, so that highest standard of care is maintained. Now, you must have heard about that it is the standard of care. Of course, it's again a legal terminology which must be maintained. And the during the litigation, possibly the doctor may have to prove that the uh, the standard of care was the highest or best possible to the circumstances. So this is first thing. The documentation. Now it is beyond doubt that what will save a medical professional in the court of law is documentation. So a meticulous record of a patient care must be maintained by a medical professional, and of course, it is true for the anesthesiologist as well. So that includes the preoperative assessment, intraoperative monitoring, and post-operative condition, post-operative reporting of report of a patient's condition. Now, PSC, that is a pre-anesthetic checkup. Whatever may be the patient, whatever may be the surgery, it's always better to write a pre-anesthetic checkup, and that document will definitely save you. I'm going to discuss one recent judgment by Honorable National Consumer Disputes Redressal. I'm going to show you that judgment in which the importance of documentation has been uh, mentioned. The communication with the patient. So this is again an important aspect. So effective communication with the patient and the relatives is important. Though it's always unpredictable that in spite of best possible communication, you might not get the proper response from the patient and patient's relatives, but still you must have your own strategy designed to communicate with the patient and always document everything that you have communicated with the patient regarding the details of the treatment and all anesthesia aspects which you are going to share with the patient's relatives. And finally, it's a risk management. So the strategies to risk management, they must be in place. You must be aware now uh, the days have changed, and the practicing anesthesia or practicing medical profession has become a different one as compared to the previous, we can say, or the past as such. So we must have a risk management. We will definitely discuss about what is the meaning of risk management in next this thing presentation as such. So now, so this is about the first presentation, and now I'm going to share with you another presentation which will discuss in short the yes. Now, as I was discussing with you, the liability of a medical professional is discussed in various judgments, and it is Honorable Supreme Court's judgments citing various principles is binding upon the all courts of India, and this doctrine is known as the doctrine of stare decisis. Now, the legal precedents, that means the judgments and the principles came out of the judgments must be known to the medical professional. Of course, uh, even before, even if the medical professional or even an anesthesiologist is not facing any kind of litigation, he must be well versed, or rather, the medico legal education must be he must be aware of the legal aspects of the his profession, and hence the judgments and the principles which have been spelled by the judgments should be known by the medical professionals. Now, the duty of care, that is the legal responsibility of the anesthesiologist. Now, while discussing this particular aspect, uh, this whole concept of legal duty and the duty of care, it emerged in one of the very first judgment which was given by Honorable Supreme Court of India. It was a case between two doctors, Dr. Joshi versus Dr. Gopal. And this was in the uh, around 1969, I think. This case was from 1954. The son of a one doctor, this was case from Maharashtra, suffered from, he was a young person, suffered from a fracture of the shaft of the femur. And those days in 1954, he was taken to or an orthopedic surgeon in Pune. See, those days he was transported from that remote area in Konkan area to Pune. Now, after reaching this particular place, uh, while applying the splint to the fracture, to the thigh, uh, before even the sedation was given, the traction was applied, and suddenly the patient died because of the cardiac arrest. So a young man died because of the cardiac arrest. The patient was transported from a remote area to this particular person. Now, subsequently, the litigation that the orthopedic surgeon faced in the Supreme Court finally came out with the explaining the principle of duty of care. So the medical professional does have duty of care, and this is nothing but a legal responsibility to treat the patient. So that care is quite important and it must be a standard care. So for considering the anesthesiologist's responsibility, the skill and expertise is quite important. Apart from the qualification, the anesthesiologist should also have the skill to give anesthesia. Of course, those who are qualified and in a practice, they do definitely possess this particular skill. The standard of care. No, this the medical professionals or even we as an anesthesiologist, uh, we must take care of the standard, and how standard can one can know that one is practicing with a care which is quite standard. So the he must know basically what is the standard, and uh, must be able to, of course, document. So documentation must show that the care which he has undertaken while administering the anesthesia during the surgery was a standard one. So the anesthesiologist, he might be practicing in a various hospitals or is practicing in periphery. So he must be, with the help of a document, he must be able to show that this is the standard with which he has practiced. Patient safety should be of utmost importance, and the monitoring and management of the patient. So for everything, for everything, it is the documentation that will take care of the uh, uh, the legal responsibility, there is a liability of the medical professionals. Now, standard of care for anesthesia negligence, the Bolam test is applicable to all specialty, and hence the accepted medical practice. So one must understand that this is the accepted medical practice, and which must be uh, followed by the medical professional. In our case, it's anesthesia. So with the help of the documentation. So without we can say, neglecting to document. The anesthesiologist must document to show that he has uh, given the standard care which is completely fitting and in compliance with the Bullock test. So this was one case, Arun Kumar Mangalik versus Chandra Kumar Jha. In this case, he was a young patient of appendicitis, developed complications. Now, what happened was the proper monitoring of this patient was not done. And obviously, the documentation was very important. So finally, the court decided that there was a negligence on the part of anesthesiologist, and hence the proper monitoring and timely interventions in case of a patient's treatment in the operation theater are important. Now, this is another case, Savita Garg versus Director of National Heart Institute. Here, the husband of Savita Garg patient, Mr. K.K. Garg, he underwent a complex cardiac surgery at the National Heart Institute in Delhi. Now, the complications were supposed to be because of the patient's condition. See, patient usually comes with in a complicated state, but most of the times the anesthesia complications may add to it. So, while uh, giving anesthesia, one must document whatever happens during the anesthesia, the pre-operative condition, intraoperative monitoring, and the post-operative. So everything should be documented properly. So here the complications were uh, responsible for the death of a patient. So finally, the court said that there was a medical negligence and careful monitoring and timely intervention in the critical case could not happen or did not happen in this case. Now, this is again not much related with the anesthesia, but I'm specifically mentioning this Kunal Saha's case, in which the Anuradha Saha was wife of Dr. Kunal Saha. Both were NRIs. We have heard about this. She was treated for a skin disorder at CMRI Kolkata, and the three doctors were responsible for the treatment. One was the skin specialist, the other one was the physician, and the third one is a critical care specialist. And in this, uh, though the Kunal Sakha, Dr. Kunal Saha, he actually interfered because this is all mentioned in the judgment. So you have to go through the judgment. Finally, what happened? The patient uh, was supposed uh, to be treated for Steven Johnson's syndrome, and finally she died. Actually, in Breach Candy Hospital, she was transferred to the Mumbai hospital where she died. No, number of hearings and number of litigations take place in number of courts, and finally, the Honorable Supreme Court said the as per the Dr. Kunal Saha convinced the Supreme Court that there was a negligence, and the important aspect it was negligence by various, we can say, while treating by various doctors, as well as it was a chain of negligence. So this could be proved by Dr. Kunal Saha, and the highest amount of compensation, rupees 6 crores, plus the interest of rupees 6 crores, so 12 crores were awarded, and roughly 10 crores to be paid by the hospital, and the other remaining amount was to be paid by the three doctors. So that was the rough this thing division of the payment. So the importance of this case is that uh, the such cases in which the compensation is being awarded as the uh, punishment to the erring doctor, they 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 uh, they can be there, and one must be, while treating the patient, one must take care, maximum take care that the medical professional do not cross the legal boundary within which he or she should treat the patient. So this is about the landmark case, and the the informed consent we have already discussed about. There is a duty to inform to the patient's relatives and the patient, and the patient has a right to choose. So this is again the important aspect. Now, while discussing about the rights of patient as well as the rights of doctors, so this is again a point which is being discussed. The patient has all the right to decide after receiving the information whether to undergo treatment, even if it is an emergency. So this is quite important thing. So without considering the patient's wish or the patient's decision, one cannot go ahead, even if without your treatment, the patient is not going to survive. So in such a kind of emergency also, it is the right of a patient which is quite important. And so this is about the importance of informed consent. So all information should be given and to the patient and relatives, and the patient's autonomy after giving information to the patient and patient's relatives, the patient's autonomy must be respected. So this is the doctor's responsibility. Now, patient has a right to choose. So this is in short this thing. Now, one more point which is being discussed, whether the doctor has a right to decide whether to treat the patient or whether to refuse a patient's treatment. So the answer is yes. The doctor also has, but the doctor will have to explain it. Uh, if suppose he has to face in the court litigation, then he has to explain the why he refused the pill. And there are a number of reasons when the doctor definitely has a right when he can refuse the patient's treatment. Now, the causation and damages. So proving the links to malpractice and the medical negligence. So usually what happens in the court of law, the complaint whenever it is filed, it's the uh, responsibility of the litigants or the complainants to prove in the court of law that the damage is the cause is responsible for the damage. Damage is nothing but outcome. It is a legal word. Now, causation or cause, it is the main aspect which was responsible for the outcome that is damage, that is a legal damage. So a link between the causation and the damage should be proved by the party which alleges. So the complainant and the legal support to the complainant, there is a responsibility to prove that in the court of law. Now, the expert testimony is quite important, as we discussed even last time also, that the since the medical profession is altogether different, the expert's opinion has an importance, and it is the government's expert committee report also has quite importance. So the expert testimony, of course, as per the Bulito judgment, as we were discussing, it must stand uh, the test of logical analysis. And thus, whenever it is proved that there was negligence, uh, the court can come to the conclusion, and then in the judgment and the order, it decides. Of course, there are certain principles based on which even the compensation is calculated. We discussed last time as well. And then the liability of a medical professional is decided. So why anesthesiology is quite important? The reason is most of the times, apart from the obstetrics, gynecology, then uh, orthopedics, surgery, and even the plastic surgery, it is the anesthesiology branch which is commonly sued. And it's the reason possibly because the uh, the dialogue between the patient's relatives and the anesthesiologist must not be there. It is left to the a leader of the team, there is a surgeon. So that might have been the basic reason. But the anesthesiologists are the ones who have to take care during their practice. And as it is sometimes it is discussed, the while practicing you must have a certain checklist that whether you have done this, so that the standard of care can be uh, seen in the document. So this is quite important. So this is about the typical legal term causation and the damages, and the link must be proved by the party which alleges. Now, what are the strategies which anesthesiologist should undertake to mitigate the risks? So, the first and foremost thing is the thorough pre-anesthesia evaluation. Now, there are a number of cases which if you search on the net, you will find that without even going through the investigations, the anesthesiologist administer anesthesia. So this sometimes happens. And then, see, whenever the outcome is not up to the expectation, or whenever there is a some complication takes place, in such conditions only the relatives, suppose a death happens or the patient goes into the vegetative state, which is the biggest, we can say, a problem for which is being faced by the hospital and the anesthesiologist as such. Now here, if a proper pre-anesthesia evaluation is done, there is a note written about the pre-anesthesia checkup. So this will always save an anesthesiologist from, of course, looking at the investigations, and whenever it's not possible, or whenever the patient is not fit for surgery, one has to refuse the surgery, and that should be documented basically. So thorough pre-anesthesia evaluation is quite important. Secondly, the continuous monitoring is uh, important. And uh, we all know that it is the documentation that is quite important. So continuous monitoring must be seen in the documentation. So you must be able to provide the documentation that the patient was being continuously monitored. Then the anesthesia techniques being used were quite adequate. So see, what happens is whenever the things go wrong, then retrospectively, with the legal help, the uh, complainants or the patients or the relatives of the patient, they come out with various, uh, we can say, the factors or the parameters on which possibly the doctors uh, might have been negligent. So in that, the adequacy of anesthesia technique, so that is also being questioned. And finally is the teamwork and the communication. So nowadays, since the NABH and ISO and the JCISO, these uh, uh, quality management principles and techniques are being used, the accreditation is being used, practicing the quality principles will always save a doctor, a team of doctor, and a hospital. So this is quite important. So for specifically for anesthesiologists, while mitigating risk, these are certain aspects which one must consider and one must uh, practice very cautiously. So this is quite important. I think finally the lessons and the way forward is the importance of monitoring. So for an anesthesiologist, it is the monitoring is far more important. Document everything. This is quite important. And this documentation must not be left to the junior. This is quite important. Secondly, informed consent. Surgery specific informed consent should be there. For an anesthesiologist, the various techniques must be known by the patient's relatives and the patients, so that your consent must inform the various aspects of the information about the anesthesia. and let the patient go ahead with the informed decision. And finally, it is the responsibility and the accountability. Nobody can shrug off the responsibility and the accountability. So rather than that, it's always better to face the whatever complication that takes place and treat the complication. Show that you were already aware that such a complication can happen and you were ready and prepared to face the complication as such. So that must be shown by the anesthesiologist. So the standard documentation is quite important. And as I even discussed last time, or even uh, what I always think, that the associations of various specialties like Anesthesia Association, I'm sure Anesthesia Association also has come out with various documentations or various standard of care protocols as such. So if whenever they are in place in the court of law, they can be referred that these are the protocols which I, as an anesthesiologist, have followed. And thus, this will definitely save in the court of law the uh, anesthesiologist. Now, I think yes. So this is about uh, right. So this is about a very short discussion on the various aspects or the legal aspects of the patient's treatment for an anesthesiologist. Now, I'm aware that it's a subject is so much intricate that the intricacy of treatment is quite important, and there are a number of aspects which one must consider while treating the patient. For an anesthesiologist, in a nutshell, uh, what can be the final conclusion is that the uh, legal responsibility is there, and nobody, no time, I think this particular scenario or the situation will go away. And hence, while practicing, the anesthesiologist must always be ready and prepared to face complications. And I'm sure we all are ready to face the complications. The informed decision by the patient's relatives. It's a documentation. Pre-anesthetic, we can say the uh, checkup as well as the preparation for the anesthesia. So that must be seen and documented. Monitoring intraoperative and even postoperative, uh, the monitoring of the patient. So that should be seen in the documentation. So as an anesthesiologist, possibly you have more responsibility to give anesthesia to the patient and also document all the aspects. Now, while discussing about various laws and acts, we have already seen that the laws that take care of the licensing of the individual doctor as an anesthesiologist, they are certain, and uh, we are well aware about the Medical Council Act and currently NMC. And the second broad heading is the patient safety. And we have already seen that under all acts and under all laws, it is the documentation that is going to save a medical professional, even the anesthesiologist as such. And third point, which I would like to just request all of you, that whenever you are working in a group practice or as a group, it's always better to have strategic relationship with all. So that means the relationship between a surgeon and an anesthesiologist, it must always be cordial. So that will always save the skin of an anesthesiologist. So I think these are certain things which I have discussed with you. There are a number of other aspects also. They can be discussed in depth. A training must be uh, obtained by a medical professional. How to remain safe in today's era, what principles while practicing he must understand and have a safe practice. So that must be that's it's a part of a, we can say, a training which every doctor must have. So I think with this, let me stop here. And these were very short presentations and the discussion. Possibly, we need still further in-depth discussion on the same subject, but due course of time, let us see when we can do. So with this, let me stop here. I thank Dr. Mahesh Sinha sir for inviting me for this particular session, and uh, would like to have some comments from you or even the interactive discussion. I would request Dr. Shivkumar Kumbar to say a few words and add to whatever I have discussed. So I thank Dr. Sinha sir. We have a question answer session now.
Yes, sir. I will also request Dr. Kumbar to say a few words in his comments.
Yeah.
Yes, sir.
Thank you, Dr. Sinha sir and Kakle sir. It was excellent and very lucid, very crisp. Okay. Whatever supposed to be covered in 3-4 hours, you covered it in 1 year. Thank you, sir. And as you rightly said, you have emphasized on the PAE, pre-anesthetic checkup, especially all cases, major, minor, or supra-major, semi-elective and elective, should be evaluated, because most of the times even judiciary say that whether you have done a pre-anesthetic checkup, okay, many times the overconfidence of anesthesiologist, take the patient inside the OT, put in a spinal position, and come and induce. Many times they don't even see the patient face and they really scrub and go and give spinal. After that, they'll come to know that patient had a restrictive cardiomyopathy or severe mitral stenosis and lands up in a problem. So I think probably everybody is aware that when you talk about the PIA and the physician fitness particularly, so anesthesiologist usually ask for the physician fitness, and no longer it's being asked now. It is only the surgeon who will ask for the physician fitness. So the relevance of a physician fitness is totally a misnomer. Okay, it is the discretion of the anesthetist who should ask the physician to have a compromised, if it is, bring it to the tack, optimize the patient for the surgery. I think one Arnab and Kataria was this Navdeep clinic. It's a very well documented case from Gujarat, the state commission, wherein a patient middle-aged who went for the orthopedic surgery, forearm fixation, and surgeon took a opinion of the cardiologist who gave patient is fit for surgery, which is a BP of 150/100. ECG was showing, ECG showing STT changes, which is said non-specific. And anesthetist, when the cardiologist given an opinion, he cannot say no, otherwise he will not be called by the surgeon. So intraoperatively, there was a cardiac arrest, and patient was intubated, cynos, and had a arrest. So cardiologist himself rushed into the OT and is certified the cause of death, MI something. The court opened only two things. Why did anesthetist listen to the cardiologist? He did not use the independent discretion. The other one is, since the BP is 150/100, the cardiologist would have deferred the case till the hypertension is become this thing. So ultimately, it was awarded 4.5 lakhs or something, for which anesthetist was to afford 60%, cardiologist 10%, since the hospital was vigorously liable, wherein it had not kept the defibrillator in the OT. It was about 30%, I think. This is the importance of PAE as well as the physician fitness, sir. Thank you very much. If I have any questions, probably I'll be happy to share with the Santosh Kakle, sir.
Yes, sir. Absolutely.
Yeah.
Thank you, sir. There are few questions and suggestions in the book.
One more thing, I think Dr. Kakle sir will also agree with me. Many times surgeons, especially gynec and general surgeons, and they say that, sir, we have taken on-table death consent, okay, and very grave risk consent. So, sir, Kakle sir, I have not heard any of these in the literature also. Grave risk consent means none of the patients will agree to go towards the grave intraoperatively or postoperatively or in operation theater. I think it is not acceptable. It is not acceptable. Even many times they ask us on-table death consent. I think it has no legal sanctity. As per the ASA, American Society of Anesthesiology, we all anesthetists we'll follow it. Even now also, we don't have ASA guidelines for the risk certification. We have grade 1, grade 2, grade 3, grade 4, but nothing like grave risk or untable death. But we have a high risk consent, okay, wherein patient has comorbid conditions which you need to explain to the patient relatives, that automatically falls under the grade 4 risk, but not the grave risk.
Yes.
Thank you,
There's
sir.
a question on the role of video consent.
Kaklesh sir, please.
Yes, sir. So, the see, no consent is foolproof. So that
Yes.
you should understand. So everybody must understand that whatever precautions you take while taking consent, no consent is a foolproof. So, but audio visual consent definitely will help if suppose you accept a consent while explaining, so treating doctor, explaining the patient as well as relatives, and then obtaining consent. Of course, the importance of documentation is quite there. So there must be a supportive document as well. So nowadays, audio visual consent will definitely help and will be accepted in the court of law. But in the consumer courts, you will see that the documents are being accepted as the evidence. And as such, the audiovisual consent, if at all you forcefully say that we have this consent, possibly you'll
Yes.
have to make a request to the judges that see I have this particular consent, because then it's a legal validity or legal sanctity also needs to be checked. So definitely that is useful. You can definitely practice, but the importance of the document as an informed consent will always stay.
Sir, there are 2 points. One is that in the transplant, it has been made mandatory now to take the
Yes.
video recording
Yes,
and
sir. Yes.
what you were explaining, and the consent is also taken.
Yes.
But another thing is it has to be very comprehensive.
Yes.
When you are writing, you may miss something. It is maybe you say that it was told, and but when you are video or audio recording, it has to be very comprehensive and include most of the thing, if not everything, because even the code says it should include all the complications whose incidence is more than 10%. So
Yes.
that is one of the point. यानी दुधारी तलवार भी साबित हो सकता है कभी कभी.
That is true. That is true. Yes.
Death on table you have already. Another standard pre-operative anesthesia consent mentions most of the common adverse events. Patient signs it up. If alleged that it wasn't explained, are we liable? Sure, I think.
Yeah. So the consent must mention the relevant complications of the procedure, surgical procedure, as well as the anesthesia being given to the patient. And as Dr. MaheshSinha sir has already told that in Indian situation, it is in one of the judgments, it has been mentioned that the complication rate of complication more than 10% must be
Yes.
explained to the patient. And if it is less than 10%, then it may not be necessary to mention and
Yes.
to be told to the patient. So it is
Yes.
as per the judgment of one of the court, Supreme Court. So this is about the um, yeah. What was the question?
If it allegation is there that it was not explained, the consent mentions everything, but the
Yes,
patient alleges that it was not told.
right. See, there are multiple aspects for this. The patient or the relatives will always say that this was not explained to us,
Yes.
because this is, you must take it into consideration. So if you suppose there is a pre-printed consent where you have explained everything, or it has been printed that this can happen, that can happen, that can happen, you may die also. So everything has been printed.
Yes.
But if the patient doesn't understand English, your consent is at weight. So this will not be accepted by court of law. Though the issue of pre-printed consent is yet to be finally solved by, or it is to be decided by Honorable Supreme Court of India, still it's always better to take something in writing from the patient or the legally responsible relative. So you have to take it in writing that he has understood it has been explained in the language which is understood by him. So this must be, so if suppose a patient is having Kannada as a mother tongue or Marathi as a mother tongue, so that must be also explained in his own mother tongue. So that, and
Yes.
there must be a documentation, because the
Yes.
documentation will, that is the only thing which will be accepted by the quota.
And even sir, as you rightly said, one of the judgment,
Yeah.
if the complications are remote, you don't have to tell it. As substantive complications, maybe more than 10%, you should bring to the notice. Even
Yes.
if you tell a remote complication, probably none of them will accept the anesthesia on the table. Yeah. And as you rightly said, sir, uh, I think signature of the patient, which is a witnessed signature, has a more value in the court of law things. That also should be known by the surgeons as well as the anesthetist. A witnessed content, maybe disinterested, maybe patient side or doctor side, it has a more
Yes.
value, sir. As you rightly said, the vernacular language is a must. Thank you, sir.
So the elements of informed consent, while
Yes,
discussing
sir.
about the elements of informed consent, number one is the name of the patient must be clearly written, because most of
Yes,
the consent, what happens, the name of patient is not written, the age is not written. So the blanks are there, multiple blanks are there.
yes,
So you one
yes,
must take care of filling up those. This is one. Name of a surgeon, treating surgeon or treating doctor. So that must also be mentioned there. Third thing is that uh, apart from general consent, the
yes,
specific consent related to the procedure, surgical procedure and anesthesia. So anesthesia consent must be a different one, a separate one, and the surgical procedure consent must be a separate one. So this is quite important. And then one has to explain everything in that. So in short, and
yes, sir.
it is in the handwriting, and if it is possible, take it from the patient's handwriting that I have been explained all these things. So who should sign this consent form? Patient himself or herself. Only
Yes,
patient has the right to decide. The relatives cannot decide. But
yes,
if suppose the patient is not in a condition of signing the, patient might be insane or might be unconscious, in that case, legal guardian can, but that must be proved, or that the document must be there that he is a or she is a legal guardian. So this is one thing. The treating doctor must sign, and the date and time also must be put below the signature. And as Dr. Kumar sir was telling, two witnesses, one from patient side, one from the doctor side, should be signing on that. So such a informed consent possibly will be a foolproof informed consent, but still, please remember that no consent will be foolproof. So
yes,
see, in one of the, possibly I might have discussed this in my last interactive session, that in one of the cases when there was an appeal, so I was on this side when I was hearing the appeal, I was surprised to find out that the grounds of appeal were 22, and the district commission, what had district commission had done, that district commission was actually, or district forum had actually given the decision that there was no negligence. So against
yes,
that, the appeal was there, and the patient's advocate, a very senior lady, and the lady advocate, she was very good. But then I could understand that it's possible to find out grounds of appeal for each and every document or the entry which you make in your document, that is in the record. So it's always better to make all entries very responsibly, because whatever you write is going to get challenged in case of untoward instance. It is going to get challenged in the court of law. So
yes,
finally, in a nutshell, no informed consent will be fulfilled. So that you must
yes,
understand. You have to take utmost care and then defend it. So
yes,
rather, I always suggest that though advocates are available to defend you, still it's always better that a doctor himself or herself prepares and defends himself or herself in the court of law. In the consumer
Yes.
courts, it's possible. Then you will be
Rightly.
able to, definitely you will be able to, of course, you have to prepare yourself in a better way. So whenever you don't have any case against you, you have to prepare well in advance. You may be able to help your colleague to defend himself or herself. So that's just my suggestion.
Yes, sir.
Yeah,
Another question
any
is,
other?
sir, about the faulty drugs administered by anesthesiologists leading to reaction mortality. Are we liable? Unique situation in our country.
Question, question. What is the
Yeah,
question, sir?
Faulty
what is the
drugs administered by anesthesiologists leading to reaction or mortality. Are we liable?
question? Faulty drugs.
Yeah.
What is fault?
Means spurious drugs means.
Spurious.
Yeah.
Spurious drugs. Yeah. So
It,
as such, it's not possible, I think, to even identify. Uh,
Yes, sir.
but one must be aware, one must have the knowledge about the spurious drugs as such. So while administering any drug, one has to uh, be sure that whatever drug you are intending to administer,
Yes.
the same drug which is not out of this thing, it's
ex,
you
expiry.
can say expiry. So, and a proper dose you are giving. So you have
Yes.
to mention the dose as well. So again, coming back to the same point, that is the documentation, you have to while documenting, you have to be very much careful, and the role of anesthesiologist is quite important, far more important. So
Yeah.
you must be vigilant while documenting.
Yeah. Sir,
Sir,
in this I had to add, Shinha sir, many times as
yes.
anesthesiologist, probably many anesthesia colleagues are also there. The commonest I came across a few days back, one patient, usually for spinal we give bupivacaine heavy. So by mistakenly, all over India about 6 incidents have happened. Mistakenly, the same looks alike ampoules, especially the tranexamic acid. Okay, that is also 4cc, this is also 4cc. So inadvertently, by mistake, error in the medication, if it's given as a spinal, the mortality rate on the table, in spite of the best efforts, is 50%, sir. So make sure that unless what you are giving is a drug which you have to open it, even if it's a waste, don't worry about that. You open yourself, or else it has to be open in your supervision. Then you give the spinal, especially bupivacaine heavy, because they look similar, unlike drugs, especially with the tranexamic acid, sir, or pause.
Yeah, there
One
are
more
many drugs look alike and sound
Yes,
alike.
sir.
There
sound
can
alike.
be a, yeah. Yeah.
One more suggestion.
Sir,
Sir.
The ampoules of used drug and the vials as well, they must be preserved. They must not be thrown away. So this is
They should
because
not run away
they are
to
the
the.
ones, yes, they are the ones who will possibly will help you in saving your
Correct.
skin whenever something unwanted happens. So
Yes,
it's always better to take precaution in each and every
yes,
case.
yes, sir. Sir, one more thing. Whenever there is a, for example, cesarean PPH has occurred, patient went to DSC and patient dies. So when informing the police, okay, whether because it's a very what you can say that the grave area, whether
Yes.
anesthesia should inform the patient, police station, or the gynecologist should inform the police station, sir.
It is the hospital which should inform. There
It's
must
a
be
hospital.
some, yes, sir, it is the
Okay.
hospital that should inform. And
Okay, because
anesthesiologist is
I
not
came across one,
responsible.
sir, I came across one case.
Okay.
Hospital was rented by the anesthetist as well as the surgeon. Okay, rather a surgeon, gynecologist.
Oh,
Hospital said that no, we are providing the only the ground anesthesia. We are not a technical person. We are not a doctor. And the anesthetist says that no, it is the attorney PPH you have to give. And he is telling patient is in shock. The anesthetist you have to inform the police. So rather than shifting on the responsibility, who exactly should give, sir? Both should together give complaint. What is, sir? What is your opinion, sir?
so the main important now point is what the whole team should work as a team.
Yes, sir.
And finally, hospital will not be able to shrug off the responsibility.
Yes, there is a
So
vicarious liability.
this is quite important, vicarious liability. So the hospital on his letterhead must inform. See, sometimes what happens, sometimes relatives say that you don't inform. So
Yes, sir.
the situation can turn in any way. So,
Yes.
uh, if suppose the relatives insist that you should not inform, so we don't want to go ahead to the police, and in case of death, we don't want to go ahead with the postmortem. So, in that case, the hospital and the doctors will be saved if they well in advance inform the police in writing.
Yes, sir.
So the complaint should be given, or the police information must be done by the hospital itself. So
Yes.
rather than shirking off the responsibility, it's always better that a hospital should inform the patient.
Yes. Yes, sir.
Yes,
Thank you.
yes,
In some metro cities, sir, there is a facility of you can send email also to the commissioner of
Yes.
police or the office.
yes. Yeah, yeah, it's possible.
Yeah.
Yes, sir.
Sir, one incident recently happened. Okay, that is interesting. The Drug Control Authority declared lot of drugs they are substandard and is spurious. When
Hmm,
this came, there was name of some big companies also.
hmm.
They few days after the companies came with that, these drugs are not ours. They are nakli hai, na. This is our spurious drug. They have
Steps.
our stamp. So this is another big issue in our place. Next is fourth
There is a,
ethical principle is justice. Yeah, sir, please. You are
what is
saying
the question?
something?
What is the, what
Fourth
is the question?
ethical principle is justice. Is my proposed action equitable, or how can I make it more equitable?
It's sir. One more. Repeat, sir.
Fourth ethical principle is justice.
Huh.
Is my proposed action equitable, or how can I make it more equitable?
I think let us ask the person who has asked this to speak,
That's better,
so
Uh,
that
sir.
just,
Yeah.
he or she will be able to explain it. What is the questions? Yes, please.
just, just a minute. I'll check.
Huh. When Dr. Arun Mehra has raised the hand, he also can later on speak.
Dr. Prabhat Tiwari has asked that question. Whether he is there? Hello.
Dr.
Okay.
Tiwari, you may ask the question. Unmute yourself and ask.
Dr. Tiwari, are you there? I don't see him actually. Yeah.
Sir, shall I proceed?
Yeah, please.
Well, this has been a very good discussion. There are 3 points which I noted from the discussion, 3 things which I would like to share from my experience. First of all, is that I never write clearance from whether cardiologist or anybody. I invariably write opinion, and Dr. Shiv Kumar Kumbar sir has also pointed that out. Because ultimately the decision is ours. Nobody else can decide.
Perfect.
The second point is concerning the legal competence of the person who is signing the consent, as Dr. Kakade mentioned. I came across a very interesting situation where I found that a patient coming for elective surgery was 17 years old. I looked at the consent, there was no consent there. So I said, you have to get this signed by somebody. I mean, as a 17-year-old, I cannot even ask her to sign. She said her sister will sign, and sister looked even smaller. We asked, what is your age? She said 15. We said, is there no adult available? They said, not yet. So we had to, put that case aside. So it's always better to, um, be alert to such things. And the third point is, of course, risk of DOT explained is a ridiculous term, as you have both pointed out. Sorry, DOT consent taken. What I write, I have very rarely had occasion to write this, but whenever I have, the word I have used is risk of DOT explained. So I'm not asking for a consent. I'm just saying this risk has been explained to you. These were the points. So thank you.
Thank you. Nice one. Nice one. Any other
Next,
questions?
yeah, there are few, sir. How much indemnity cover should an anesthesiologist have in today's time? I think you have explained it in the previous session
Yes,
quite
sir.
elaborately.
So it should be at least 2 crores, at least 2 crores, because anesthesiologists and the plastic surgeons, they are the top ones who should actually have more risk which is covered. So 2 crore cover with professional indemnity insurance with 1:1 ratio. This is quite important. And the what we can say, it must be renewed every year. And last time this was discussed by me as well, that till what time it should be obtained, till what time. So whenever you stop practice, 2 years after that also, you must have certain provisions are there in the insurance company. So you have to have it because the limitation is 2 years. Limitation period is 2 years. So this is in a
You
nutshell.
pay low premium also in those years actually when you tell the insurance company you're not practicing.
Right.
If the expert panel gives a unfavorable opinion which is not correct, can we appeal in higher court?
Yeah, it's possible. That can be challenged.
There is no implementation of guidelines in operation theaters. Who is responsible? Government, management, surgeon, and anesthesiologist.
See, guidelines means what guidelines? OT guidelines.
Is any guidelines whatsoever they've been given for say for if you are quality and safety and all those things. I think it means Mohan Pathak he can speak if he is there.
See, finally, it's always better
Yes,
to,
I am Dr.
yes.
Hello, yeah, please.
Yeah, please go ahead.
Rules and
Your voice is breaking, Mohan.
implemented.
Hello.
So ultimately the rules are not followed. Implementation of the quality control is not maintained. So who is responsible? Actually, authorities also they are not looking into the matter, and we are always deprived of the facilities. Whenever the government or private.
Yes. So actually, the answer to this is even last time I had discussed that as an anesthesiologist, you have your own set of rules. Of course, they should be based on the legal guidelines and you follow very strictly. That means in every case, you are going to make a note of pre-anesthesia checkup, number one. Number two, and because that is going to save you. So even if the rules and
Yes.
regulations are not existing for any hospital, you will have to have your own set of rules. So for that you will have to prepare your checklist that these are certain things which I am going to follow for each and every case. Then document that you have seen the investigations. This is second. Number three, your opinion you have written about the after the pre-anesthesia checkup. Then, if the patient is fit and the grade of anesthesia, or you are better having this knowledge of grades of anesthesia. So, based on the patient's grade, you mention it there and then give anesthesia. So, the anesthesia notes, intraoperative monitoring, they must be in a proper format and proper fashion. So, ultimately, you have to have your own style of working as an anesthesiologist. Style means it's a layman's word actually, but then you have to have a strict protocolized practice. So even if you are in a private practice, it's always better to understand what goes wrong or what is considered as a negligence by anesthesiologists in the court of law. So if you know certain aspects, I think you will be able to having a safe practice.
Yes.
See to it that you have taken proper consent. See to it that everything has been explained and you have signed as an anesthesiologist because it is a separate anesthesiology consent. And then, as an anesthesiologist, you will have a responsibility to see to it that even in the post-operative period, once the patient is awake, you have to make it a policy that till what time you will make your notes, you write your notes. So
Yes.
that you will be able to explain to the court that, see, I have taken anesthesiologic care of this patient from end to end. So from pre-anesthesia to post-anesthesia.
Actually,
Sir, one more
sir,
thing.
I want to ask two
yeah,
more
please.
questions. Two more
Yes.
questions. One thing is whether Ayurvedic anesthetists, they are trained in some hospital, they are allowed to administer anesthesia independently.
No, sir.
Other doctors, Ayurvedic anesthetists,
Sir,
they are not allowed to.
ISA guidelines, Indian Society of Anesthesiologists, it has come up with a beautiful guidelines in the year 2000, 2020 and 2021. Guidelines for the pre-anesthesia checkup, guidelines for the way anesthesia professionals should be practiced, and none of the non-anopelic doctors should give anesthesia, sir. They has to be registered under the respective state medical council or else NMC. So Ayurvedic, there is nothing like Ayurvedic anesthesiologist, sir.
Actually, in practice, there are so many NAT practice outside. See, let it be. One more thing I want to ask, the compensation awarded to the patient in case of tragedy is very in crores of rupees or crores of rupees and all. Where the expenses of the surgery or the facility or everything, it's a very small amount. But patient compensation is they get in crores of rupees, 2 crores, 10 crores, whatever. So there is a wide disproportion in expenses
Sir,
of the procedure and compensation awarded. That I want to say.
sir, amended the Consumer Protection Act 2019. There is no capping for the compensation being asked. But there is a
Compensation.
cap. Yeah,
Yeah.
there is no capping or limitation for the compensation being asked. But there is a capping for the consideration being. So if it is a 50 lakhs and less than that,
Yeah.
the court case will go into the state commission, sorry, district commission. If it is between 50 lakhs to 2 crores, it goes to the state commission. If it is more than 2 crores, it goes to the national commission. Even if the hospital bill is 10,000, they can ask a compensation in multiples of crores.
Yeah.
See, Dr. Pathak, this can be answered in another way. That, see, even if the compensation being awarded in we can say the amounts of compensation is increasing, there is no exorbitant compensation being awarded as such. There is certain, we can say, a principle based on Supreme Court's judgment. Sarla Verma's case is there. So based on that judgment, the compensation is calculated and then it is being awarded. In very few cases, the higher amount of compensation has been awarded. So, and another thing is that we cannot ask a question that why this compensation or capping of the compensation. It's actually, I think it's not useful to discuss this type of compensation. It's because very, very exorbitant compensation are not being awarded. So if you go through number of cases, you will find that certain principles are being used to award compensation. So in a nutshell, your cover for professional indemnity cover, it should be at least 2 crores. So that is in a rough way, it is being advanced.
Yes, sir. Agreed. Thank you, sir.
Sir, Kakran,
Yes, please.
Kakran, sir. As an analyst, I have one question for you. Many times, it's a practical problem, whether the choice of anesthesia is the domain of the patient or the anesthesiologist. One. Okay, for example, I have chosen a spinal anesthesia for a simple orthopedic case or a cesarean. Patient insists for the GA. I know that GI is detrimental to our health, but the patient is insisting for that. So if untoward occurs, we cannot say that the patient has chosen it. So how do you interpret, sir? I have come across one case like this.
So, see, I think it's very tricky. The
Yes, sir.
situation is very tricky. So, deciding what type of anesthesia should be given to the patient is a completely the prerogative of the anesthesiologist.
Yes, sir.
Quite important.
Yes.
So, what to explain to the patient that the patient, the type of treatment and the anesthesia. So, that should be informed to the patient. See, the patient cannot demand that this should be, if the patient's health status is not good and giving the general anesthesia is going to cost possibly the patient's life. So in that condition, the anesthesiologist is the one who has upper hand to decide. So
So
I
that
don't think,
yeah. If many times in ethical practice say that we have to respect the patient and not autonomy, right? Okay. So in that case, I have come
That is
across that,
not-
sir. One situation. Ultimately, I cancel the case. I say that you go to the institute. I want to give you this case because you have cardiac problem. You are choosing for that. I'm not for that. Yes. Thank you, sir.
Yeah, that should be the principle actually. In one of the cases, the court gave decision because why you took a high risk patient in a small nursing home where there was no ICU.
Yes,
Actually,
sir.
people are interpreting it that every hospital should have ICU. It is not like that. I
It's
think
not
it
like
is
that.
that what is your facility, what you are having facility, depending upon that, only that type of cases you should take. If you are a bigger hospital with the ICU and all the specialty, then you can take higher risk cases. Otherwise, you are not supposed to take a grade 3 or grade 4 case in a small nursing home.
Yes, sir. Yes.
if finally you as a doctor must be able to document and show it to the court in case of the if suppose litigation takes place
Yes,
that
sir.
you were aware of what complications can happen, number one.
Yes.
Number two, the complications were explained to the patient. Number three, the hospital or myself were having the preparation to face
Yes,
such
sir.
a complication if it happens. And see, nothing is acceptable orally. So you must have a documentation. So you were ready to face the complications, and this preparation, what you have, was informed. See, it's a somewhat complicated thing. But then if suppose you are successful in showing the court that everything is documented and the hospital as well as I was ready to face the complications, I'm sure the courts will definitely accept that you were aware, you were ready to face the complication, the preparation was there, and in case that happened, we went ahead and used the same protocol which we were supposed to use. So that if suppose you show it and see, finally what happens that whatever care you take, every kind of even better care also, or even a better outcome also can be challenged by the patient. And patient means the
Yes.
legal practitioners.
Thank you, sir. Thank you.
Yes.
And many a times, off late, sir, okay, unlike previous days, when the patient is settled intraoperatively, monitor is going on, anesthetist had some sort of chit-chatting or going to the iPad and tweeting and busy with the Facebook and other things. I read and beautifully one article a couple of days back in Texas, okay, and a 60 years old woman who was for the low risk cardiac surgery, okay, intraoperatively patient had arrest and the surgeon alerted. By the time alerted, 50 to 20 minutes had passed away. Patient was already in a vegetative state, okay, encephalopathy, hypoxic encephalopathy. The court retrieved it judiciary. They came to know that anesthetist was busy with his iPad, sending the mails here, things. The court categorically said, treat or tweet. And he was penalized heavily, sir. I think in one of the hospitals, they made a protocol, no mobiles are allowed inside the OT. It is a silent zone. That should be adopted because everybody has a tendency. When a surgeon is also doing some comprehensive surgery, he asks the anesthetist to take the picture Okay, that is also not allowed as per the recent BNS Act as well as the Consumer Protection Act, sir.
Yes. True. Absolutely
Yes,
true.
sir. Yes, sir.
Sir, in the
Any
foreign
other
country
question?
somewhere, the anesthetist was charged here negligence because he was on the mobile chatting and all, and his mobile was checked.
What is the question?
Say, other than listening to the taking care of the patient. So he was terminated or something because he
Yes.
was busy with his mobile instead of taking care of the patient. This is the
So
incident.
in short, one has to take care because
Yeah.
one should
Yes.
understand that you are there for safety of the patient, and that you should do nothing which will affect the patient safety.
It is
So
called
that
as
is
the
quite important.
distracted. It is called as the distracted doctoring in the OT.
Yes. See,
Uh,
I came across one case where in a hospital for a hysterectomy, anesthesiologist gave us final anesthesia.
Yes, sir.
Okay. And since it was a private hospital, the hospital did not have that boys met. Of course, this was quite way back. Boys was not there. Then even the ETT tubes and everything was not there. So those were the days, say about around say 15, 20 years ago. The anesthesiologist, thinking that the spinal anesthesia will be safe, he did not bring the kit, her kit, inside operation theater. So you see, what
Okay.
is the gross negligence, isn't it? And then it was very difficult. No endotracheal tube was there in the operation theater when the cardiac arrest happened. Finally, somehow they could manage to revive. But then the patient was in a vegetative state and she was there for almost 6 months and then she died. So, see, this was a gross negligence only.
Yes.
So, any kind of such negligence is possible. So, the only suggestion is or advice is that you have to decide your own practice and you have to decide your own, we can say, principles or protocols while giving anesthesia to the patient.
Thank you, sir.
Sir, there are a few more questions. Will you be able to take them?
No problem. I think we have, say, 5 or 10 minutes. We can
Okay,
definitely.
sir. Some are the types of plan of anesthesia. I think that is weird, beyond the domain of our discussion, medical legal.
Types
If
of,
there is a language barrier, what you
huh,
will do?
huh. If the language barrier is there, then the person
Translator.
who understands both the languages, so should be made available. He should be there. He should also sign that, and this must be clearly mentioned in the consent that this such person who has knowledge of both the languages has explained the details to me. So that must be written and then signature should be obtained.
There are complications, both anesthesia and surgery related. Who will take informed consent, surgeon or anesthesia or both? Complications occurring during intra because of surgery, who is responsible?
See, you will be responsible as a team. So this is quite important. So surgeon, anesthesiologist, and the team of treating doctors. So uh, it cannot be, we can say, given to any one doctor as such. But the treating doctor or the surgeon will have definitely a main responsibility to explain. If suppose it is possible for him to come out and discuss and talk with the patient's relatives. So, uh, and it's always better to have a team approach. So if something
Yes.
wrong goes, the surgeon as well as anesthesiologist together can explain the things in a better way to the patient's relative and patient, and of course those who are legal guardians to the of the patient.
In
And
this
for the
case, sir, a couple
consent,
of long back, Master PM Ashwin versus Manipal Hospital in Karnataka. A small boy was operated for the hernia. Since there was a hypothermia inside the OT, like hot water bottles were kept beneath the thigh. Post-operatively, they came to know that there was a churning of the skin and a loss of skin. In that situation, both anesthetist and the surgeons were responsible, and they were accountable, and they were asked to pay compensation, sir, both of them. Both of them were jointly and severally made responsible, sir.
So,
actually,
huh.
in the question, there was a part of consent also. Actually, everybody is to understand that the consent for surgery and anesthesia has to be always separate, whatsoever be the.
Yes.
Yeah.
Definitely, it has to be separate, sir.
Yeah.
Absolutely.
Yeah. In trauma case with no relative and unconscious patient, which consent is legally acceptable? You don't require consent, I think. In
Trauma case?
life-saving situation.
Uh-huh.
No, sir. In a legal guardian is required. Even if it's not there, the head of the institution or the police people are also responsible if none of them are there.
I think every doctor will definitely remember that whenever you were undergoing your training in civil hospitals or the hospitals attached to the medical colleges, when we were facing such a situation when the unconscious patient is brought in in an accident. So while operating upon such a patient, it is the medical superintendent or the chief of the hospital or even civil surgeon's consent is obtained. So if there is no legal guardian available, so it is rightly discussed that the hospital's head will give a consent. It is to be informed to him that such a patient is there and you have to operate upon for saving the life of the patient.
Can you give the reference in which 10% complication thing had been mentioned?
Yes, sir, that can be definitely. I think I will share it with Dr. Sinha, sir, and then he will share it with all of you.
Next is the legal aspects of segmental anesthesia.
Legal aspects of?
Segmental anesthesia is a type type of spinal anesthesia actually.
See, whatever the type of anesthesia, you have to explain this to the patient that such a kind of anesthesia you are going to be given. And the pros and cons should be discussed with the patient. So obtaining informed consent of the patient is far more important. To obtain the consent, I think you will remain safe.
Okay.
So is there any direction like radiation safety toward the exposure of surgical smoke, which is identified as carcinogen? I think it is related to some cautery, I think.
What is the question?
It is about the smoke which comes out of the cautery, I think, which is can be carcinogenic. So is there any guide direction for that? Actually, now the modern machines they have suctions also with the cautery, so all the fumes they get sucked out.
Yes.
If you use a technique of anesthesia, still not prescribed a standard textbook of anesthesia, but enough case papers, journal publications on the technique are available. Is it legally acceptable?
Which one, sir?
If you use a technique of anesthesia, still not given in textbook, but it is enough material in the cases, paper, journal. Is it legally acceptable?
No, sir. It's not legally
Kumar,
acceptable. Sir.
Kumar, sir, you please answer.
Yeah, it's not legally acceptable, sir. Even in the as a witness or in the literature to produce the court what is to be given as the evidence in the court in the form of textbooks. First, Indian authors, reputed authors, then Indian journals, then it goes to the international journals. That's how the court will quantify the authenticity of the journals or textbooks. But if some techniques are under trial stage, okay, you cannot experiment on the in our own domain. It's a negligence, sir. It has to be done in ICMR guidelines or something, ICMR trials, but not in the routine practice, sir. Basically, why you want to practice those drugs, even if they are not available in any of the textbooks or not in the workshop, I think we shouldn't do it, sir.
Actually, I think the person asking, because many things textbook come after 4 years, something like that. There's a rotation of when they come. Before that, there are thousands of publication now coming in the media and literature, and they are being taught in the workshops also, in the different conferences also. I think he is asking about that.
But
Brother,
I don't
I request
think.
I
Yes,
request
sir.
that
You done.
person who has asked the question, he can give an example actually. If
Yeah.
he can give an example, we may have more discussion on that.
Yes,
Dr.
sir.
Rajesh Rao,
Any example of a technique which is not given in the textbook, anesthesia textbook, but you are using it. So can you just give an example of that?
Dr. Rajesh Rao, you can unmute yourself and ask. Tell.
Hello.
Yeah.
Yes, please. Yes, please.
I'm talking about segmental spinal, which is very much in vogue now. Even I say, as conducted workshop, I'm faculty on many such workshops. Internationally, also this technique has been going on for many years now. My thing is we lack documentation and making presenting papers. Once this documentation happens and the papers are presented, maybe soon it will come in the textbook. But cases have been done, and that too successfully. The success rate is quite high. We have don't have any complications so far. So that was my interest.
Sir,
So
there are two things.
finally,
See,
the answer
yeah,
is
many times, even for the laparoscopic surgery, okay, there was 10 years back, there was a controversy whether to go for GS panel, and all books mentioned that you have to give G only. Of late, over the last 4 or 5 years, even many of the conferences, even the research papers came that spinal can be given for laparoscopic surgery. We have been using it. I think probably you are also aware of it. The
yes,
question
sir.
is the two things the court should look into it. The skilled knowledge, where you are trained, how many cases under whom you are trained. Okay, that is acceptable in the eyes of the judiciary. The skill and expertise of the anesthetist has to be produced before the court. How it is justified in giving such kind of a technique, where he was trained, under whom he was trained, under how many cases he was given. That will see into that. If that technique is practiced in Western countries, if it is the prudent people of your own culture not practicing in India, probably Indian courts will not accept it, sir. Will not accept it. So reasonable professionals should be doing that kind of a process, then only they accept it. Otherwise, they may not accept it. I think Dr. Kakre will also agree with it.
Finally, the answer can be whether you use any technique which is acceptable to the professionals which
Yes.
are who are practicing as you are practicing.
Yes,
So
sir.
if you can produce a document, basically. So as you are saying that that was being presented in various conferences and all. So you should be able to present a document to the court. So definitely it will be acceptable. See, Boehm's
Yes, sir.
principle is that whatever is acceptable to the professionals practicing in your own specialty. So that
Yes.
will be accepted and it will not be a negligence as such.
Yes.
But
Yes.
then, the care which must be taken is that if at all any expected complication is there in this particular new technique, you must explain it to the patient and obtain his consent that he is aware that such a complication can take place, and
Yes.
all possible preparation to face the complication is this care has been taken by the doctor, and the patient is aware that this possible preparation is ready with the doctor who is going to use this technique. So see, finally, everything is based on the documentation. So you must
Yes.
be able to document that. Yes.
Thank you, sir.
Any other question? I
No,
think
sir, the questions are over.
many
One point I'd
many
like to add on this thing.
please.
As Dr. Kumbar said, there are three
Please.
different stages actually. One is the when you are doing a trial, clinical trial. Their protocols are totally different. A new technique you
Yes.
are trying. There's a very detailed things has to be done. Everything, even right from the explanation, consent to the compensation, is a huge separate subject in itself. That is clear. Then the in between, what I say, segmental anesthesia. This has been being used for many years, but as you said, for anything you are doing, you must have the sufficient ground to work on that and have a proper consent. So I think that is sufficient.
Absolutely. So I think, see, there will be unending questions because every aspect can be questioned. Every aspect can be questioned. And the this medical legal field is evolving. So every time something new comes and the new principle comes out. So the only thing which you should be doing is keep your eyes open and ears open and educate yourself medico legally. I am seeing that Dr. Ishwar Chandra Nagare from Aurangabad, he has joined.
Yeah,
And
he is here.
he's a senior anesthesiologist and very keen. Then Dr. Sandeep Mutha is also there.
Yeah, a lot of many senior people are here
Yes,
in the.
yes, yes, yes.
Thank you, sir.
Absolutely.
Thank you, sir.
Yeah.
Namaste, sir.
Namaste. Right.
Lastly, sir, for all the viewers, okay, as a quick message, anesthesia is a very risky profession. No doubt about everybody will agree for that. And we are the human beings, basically. To err is a human. To err repeatedly, I would say it's a foolishness. To cover up with unforgettable by fabricating the documents. And if we are failing to learn, is inexcusable in the court of law. What do you say, Kakri sir?
Or what is the exact question, pinpoint? Hello.
Yes, sir.
Hello. Kumar sir.
No, sir. The take-home message is anesthesia specialty is a complicated specialty. Okay. And
Yes.
many times, unlike other systems, we do hear as human beings. But hearing in anesthesia is a more, either it's a mortality or morbidity. There is a very thin line between the mortality and morbidity. To hear is a human, you will accept it.
Yes.
And to hear repeatedly is a foolishness. To cover up your error by fabricating the documents and manipulating, probably it's unforgettable. And to fail to learn from your mistakes, probably is unpardonable or inexcusable in the eyes of the judiciary.
Sir,
we can say that this can be a message for all medical professionals practicing.
Yes. And the other day, sir, at the beginning of my remarks in one of the conferences, I was telling, especially anesthesiologist mistake buries 5 feet below the ground. Liar's mistakes hangs 5 feet above the ground. Police officers' mistakes leads 5 years or more into jail. Media mistakes torture you every day till some other news comes into play.
Very well said. Actually, sir, the situation in our country is very different because there is very little awareness about what is anesthesia in the common people, including the judiciary. Actually, I remember somewhere in the court it was asked whether you have to go a separate study for anesthesia. So this is the situation in our country. Okay,
Thank you, sir.
Thank you very much, Kakade sir, for giving your valuable time to us, and Kumbar sir also. Kumbar sir also for interacting and giving his valuable time also. Thank you all, and thanks all the participants also who continued with us till end. And I think we'll meet again. Thank you, sir. Thank you. Good night.
So thank you very much, Dr. MaheshSinha's sir. Thank you, Dr. Kumar sir, for lively interactions with the participants. And thanks to all participants for being there till end of this particular session. Thank you.
We have been 2 hours now.
Okay. Good night,
Thank you, sir. Good night. Good night.